Hi, I'm John Miller with McIntyre Elder Law. We're going to talk today about some ways to avoid probate, and there are four basic ways that you can avoid probate. They are first, trusts; second, payable on death accounts; third, right of survivorship accounts; and finally, deed work, such as a ladybird deed or life estate deed. Let's go back to trusts. In a trust, those can be revocable or irrevocable. You can have trusts such as a charitable remainder trust or many different kinds of trusts. Those avoid probate because those are documents that are filed not in the probate office, but actually in the Register of Deeds, for example, when you are deeding property into the trust. The trust itself, however, is a private document, and you can use that for different types of planning, such as Medicaid planning or any sort of succession planning with a business or multiple properties. The living trust does not require probate. It does not go through probate, so you do save those costs and the inconvenience of the probate process. The second way to avoid probate is by doing a payable on death account. You would set these up directly with your bank. They are fairly simple to set up and simple to administer. The account opened up with your bank actually would go to a named beneficiary upon your death. So when the bank sets that up and you have a payable on death account, the funds automatically are transferred to the recipient upon the death of the account holder. Banks typically will only require a certified copy of the death certificate to make this transfer. The third option is the right of survivorship account, which is somewhat similar to the payable on death account, except for the right of survivorship account can be accessed during the life of the account holder, and also again, upon the death of one of the parties, the survivor is entitled to all of those funds. Failure to set up a right of survivorship account can result in half of those funds having to be made available to pay claims out of a probate estate. So we always suggest that you make your accounts either payable on death accounts or right of survivorship accounts. Lastly, there are different types of deeds that you can prepare that will eliminate the need for your real estate to go through probate. One of those is a right of survivorship deed, where the property, the real estate, goes to the survivor of the two parties. You can also have a life estate deed, where you convey you keep a life estate and convey the property to named remaindermen. And the remaindermen are those folks who have a remainder interest or an interest in the property upon your death. And again, both with the right of survivorship account and with a life estate deed, those deeds eliminate the need for probate. Lastly, and something that we frequently use, is the ladybird deed, and it's also known as an enhanced life estate deed. And it's a life estate deed, however, you retain the option to sell or mortgage that property during your life, and then the property is transferred to the remainderman. It provides a little more flexibility than a regular life estate deed, and is also not a countable asset according to North Carolina Medicaid rules. As always, feel free to consult me or other attorneys here at McIntyre Elder Law. I'm John Miller. It was nice speaking with you.